Scenary versus State.
Good morning, Your Honors.
Good morning.
May it please the Court. My name is Landon Miller. I represent the appellant Brian Tassinari on this appeal now pending before the Court. As a preliminary matter, I received an order dated January 7th wherein the clerk issued the order directing us to be prepared to address whether or not you have jurisdiction in this matter and whether or not this was an appealable order by the lower court. I have reviewed the cases, Your Honors, relating to that order, and I would argue to the court the first case that was listed in the order from the clerk was a 3800C motion, which was not the motion that I had filed with the lower court. I had moved under 948.03, although it was not spelled out in the motion. It was a motion to modify the conditions of probation, but more importantly, as you read through the body of the motion, is to delete a special condition that the Judge Hart had ordered for Mr. Tassinari. I would say that this court does have a certiorari review and several different reasons. Under the Weidner case, that is a case where the lower court believed it did not have jurisdiction to modify conditions of probation. I would argue to this court that the adverse or the opposite is true as well, that this court certainly has the certiorari review of a lower court that believes it does have jurisdiction to order a particular special condition. Our position is that this special condition that the Judge Hart ordered is an unlawful special condition, and it's not based in any statutory scheme. And then quite to the contrary, our position is in an interstate compact. The only special condition that you can make on a sex offender case being transferred through interstate compact is making the receiving state agree by stipulation that it will, in fact, monitor a particular probationer.
Well, it sounds like what you're saying is we don't have appellate jurisdiction, but we have certiorari jurisdiction. Therefore, we need to convert this case from an appeal to a cert. Is that correct?
Yes, sir.
All right. Well, then you need to address how your position would meet the cert standard.
I understand, Judge. My understanding of the certiorari review standard is that this court does have jurisdiction to review cases wherein there is a violation of a clearly established law that our position as Judge Hart violated. We're
not talking about what Judge Hart did now. We're talking about what Judge Schenko did, because Judge Hart imposed the restriction originally. That was appealed. The issue was not raised. So we're now here on Judge Schenko's decision not to modify the restriction in the original probation order, correct?
Yes, sir. That's correct, Judge. Then, or in another way to put it is not to rescind an unlawful condition of probation. And that is what we would submit Judge Schenko failed to do. He did not list any particular reason why he would not remove this condition. We did make an argument, Judge, that for a special condition to be heard or to be made part of a probationary sentence, that it has to be reasonably relatable to the particular underlying offense. And in this case, our argument was it does not. The special condition that Mr. Tassinari remain in the state of Florida for a period of 5 years. That is what the punitive nature of the condition, special condition is. That not only does it have to remain in Florida, not only can he not transfer out to Massachusetts, but they cannot be transferred to any other state. It has to remain in the state of Florida. Our position is that's not rationally related to the goals of probation or the goals of rehabilitation. And we did cite in our appeal the second DCA case of Rodriguez. And that for a special condition of probation to be a valid condition of probation, it has to relate to the crime for which the offender was convicted. It has to relate to
aren't these arguments that should have been made on the appeal from the order when it was imposed originally?
There was an appeal of the finding of violation of probation when the special condition was issued, Judge. The prior counsel did not make that argument to this court. And could that argument have been made to this court? I would agree with Your Honor that it could have been made with this court. However, at this juncture, we did file a motion to rescind or to delete that condition, which Judge Shanko declined to take us on the opportunity to. So I would suggest to the court that it's properly now before you, based upon Judge Shanko's refusal to rescind that condition. In addition, after the second DCA issued its opinion in Rodriguez, the Supreme Court went further in, I believe, Biller v. State, which was a 1993 Supreme Court decision, Florida 1993, cited at 618 Southern 2nd 734, which I would suggest readopts or does adopt this court's finding that a special condition of probation has to meet that 3 criteria as outlined in Rodriguez. As we noted in the court below, Your Honor, and there was evidence to the same that Mr. Tassinari is a resident of Massachusetts.
Well, let me ask you about that. I mean, you say there was evidence. Was this hearing on the motion to modify a hearing at which any evidence was presented?
There was, Your Honor. There in the transcripts on towards the end of the transcripts, I don't have the page number in front of me, but there was evidence submitted of Mr. Tassinari's real estate license in Massachusetts. There was evidence submitted.
He wasn't present at the hearing, was he?
He was not, Judge, and it was moved into evidence without objection by the state at that time. There was evidence of his work records that were moved into evidence. There was evidence of his residential status as well, which was all moved in as evidence and accepted by the court as evidence without objection by the state attorney. I have looked at the record on appeal, and I looked at it again last night. It appears that the record may be short of the actual documentation that was submitted, at least the copy that I have, and certainly I could, Your Honors, go back and do a motion to supplement the record, because the documents, the actual documents were submitted and the paperwork were submitted and accepted by Judge Shanko. Once again, it's our position that this is a cert review, that Judge Shanko did violate a clearly established principle of law, resulting in a miscarriage of justice, and based on the evidence, which I believe is uncontradicted by the state, that Mr. Tassinari is a resident of Massachusetts, that the special condition does not speak to the crime of conviction, and the special condition does not relate to any future criminality that may be committed in Massachusetts, no less than it would here.
You've made a very interesting argument in this case, but no doubt that the judge exercised the judge's discretion, because there had been previous violations in Massachusetts, and the record reflects there was arguably inadequate supervision in Massachusetts. At least that's the position that's been taken. And so if that being the case, there certainly would be evidence in the record for the judge to have made the decision the judge made. It would support the judge's decision. I mean, they could easily point to this and say, look, he's violated before. He had the one new offense, which was later no filed, if I recall, and then he had a contact issue with underage children, which violates one of his conditions. He went to a party with his girlfriend. There were underage girls present, if I recall. And there are other minor type violations, but nevertheless violations. There was also record evidence that he was sort of unsupervised for extensive periods of time during these violations period, where the argument was he was under court supervision during these times. But the judge took the position, or at least the argument was made to the judge, and the judge seemed to accept the argument that Massachusetts had not supervised him in a way that the judge felt he needed to be supervised, and he felt more comfortable that the courts of Florida would do that, or at least a probation system in Florida. Whether you agree with any of that or not, it's clearly in the record. Wouldn't that be a basis for the judge to do what the judge did?
I disagree with Your Honor's interpretation of the record as it relates to
Well, correct me for sure.
Without My reading in the record, Your Honor, is that in fact there was a violation of probation back in 2006. Mr. Tassinari was retaken by the state of Florida. So the Massachusetts probation worked on that occasion. There was another violation that spanned a period of, I believe, almost 3 months, which ultimately resulted in, at that time, Judge Hart dismissing the violation. So at that juncture, I'd say, once again, Massachusetts supervision is working correctly. On this violation, the new condition was issued, Your Honor. Mr. Tassinari was advised that he needed to come back to Florida, and he actually returned himself. There was a violation out there. He received a bond out of Massachusetts, and he returned himself, and he was actually taken into custody at the airport in Fort Myers. So I would suggest that there is no record evidence that it was not being supervised correctly in Massachusetts, and actually to the contrary, that there were violation reports coming. He had been returned once, a violation was dismissed, and he returned himself the final time. So I would suggest to the court that that actually was working. And in addition to that, Your Honors, the violations that occurred could occur here as well. There's no record evidence that Mr. Tassinari fought extradition.
And the record is what the record is.
Yes, sir.
But my point is that the state took a view of that record, which the judge agreed with. Wouldn't that be a basis to support what the judge did?
I understand the court's.
I mean, there's enough there to debate about whether or not Massachusetts was adequately supervising this defendant or not. And I accept everything that you have said to justify what they did. I understand that. I might have made the call differently if I'd have been sitting in the judge's seat. But the judge basically assessed the record, listened to the state's argument, and said, yeah, I agree with you, and made the decision the judge made. And arguably, there is enough record evidence to support what the judge did.
Except for, Your Honor, I would suggest to this court that Rodriguez does control. And this court's directions were that the judge had to meet 3 certain criteria if it was going to issue a special condition. I don't think there's anything in the record evidence that would support the criteria as Rodriguez holds it to be to make this special condition. And in addition, Your Honor, I'd also point, and I know it's in my brief, and I would rely on my brief as well, but it's in a footnote, I believe it's footnote 5 towards the end of my brief, citing C.F. Colivart versus State, 5th DCA 1991 opinion, where the appellate court said that there can't be a special condition that you can't be supervised in Kansas just because you don't believe that they're supervising you in Kansas appropriately. Of course, that had to do with restitution, and I understand that, but there was another appellate court decision that says you cannot restrict somebody's travel just because you disagree with the way they may be supervised. I'd like to reserve the rest of my time.
All righty. Well, I'll let you reserve 5 minutes.
Thank you.
May it please the court, Bilal Faruqi on behalf of the state, the appellee in this matter. I'd like to start by just summarizing our main points here. The first, basically, we're arguing that the appellant hasn't met the stringent requirement under the cert review, and I'll come back to that in a second. The second, obviously, is that we're arguing that the appellant has waived this issue by not raising it in his initial appeal. And thirdly, even if this appeal, even if it were addressed on its merits in a direct appeal, as I would agree with Judge Morris that the trial court basically made a factual finding or a discretionary decision, which is supported by the record. So even on a direct appeal, I believe that this issue that the appellant would not satisfy his burden. Now, with respect to the cert standard, cert review is typically granted in certain types of situations, either jurisdictional errors, violations of due process, or applications of the wrong law. And we can see examples of that in some of the cases that actually appellant has cited. And I would refer to, I believe it was the Stewart case, where where the lower court in that case denied modification of probation without any hearing whatsoever. It was done summarily. They basically asked the prosecutor ex parte, what do you think? And they didn't agree with the modification, so they just denied it without a hearing. And so that's kind of a due process issue. The other case, which is Weidner, where the lower court erroneously believed that it didn't have the authority to modify the probation. So those are examples of situations where granting a cert is warranted. And the last thing I'd like to address, and which is with respect to application of the law, Appellant's counsel referenced the interstate compact, and I would point out that under the interstate compact, which is codified in the Florida statutes and binding upon the state of Florida, under Rule 3.101-3, it specifically states that the sending state has the discretion whether or not to allow a transfer. And the mandatory aspect of transferring probation is really upon the receiving state. So in other words, Florida can decide whether or not this probation can be transferred, and once it makes that decision and the requirements are fulfilled, the other state, in this situation Massachusetts, is required to accept the person. So really the principle of law that we're looking at here is really that the trial judge in Florida has the discretion. So it can't be stated that a clearly established principle of law has been violated. And I'll skip over the second issue because it's pretty self-explanatory. And with respect to the record in this case, and there's a long list of facts. We've got a violation occurring with a new law violation within months after being placed on probation, which the appellant admitted that he violated. And then it took about 3 years for that violation to be resolved, during which time he was unsupervised by probation officers. And the state's position is that court supervision is not the same as supervision by probation officers. And he allegedly violated a second time. And as appellant's counsel pointed out, that violation was ultimately dismissed. But if you look at why that was dismissed, it's another example of why probation in Massachusetts wasn't working. And the reason it was dismissed is at the probable cause hearing in Massachusetts, the probation officer in Massachusetts failed to file a written report, and so the violation just gets dismissed. And then we've got the third alleged violation, which again resulted in this new restriction that the probation can't be transferred. And the last thing I'd like to cover, and I think that opposing counsel might have misinterpreted one of the cases, and I'd refer back to the Kolovrat case. And in that situation, it's distinguishable from here, where we had a probationer whose probation was transferred to another state, and the probation officer in Florida filed a violation without any consultation with the probation officer in Kansas. That's not the situation that we have here. What we have here is in Massachusetts, they informed Florida that these are the violations, and then the proceedings took place afterwards. If unless the court has any further questions, I think I've addressed our arguments.
All right. Thank you, sir. Mr. Miller, I'll let you have 5 minutes for rebuttal, sir.
Thank you. I'd just like to readdress the issue of review by cert. In that Rogers stands for the proposition that there are extraordinary circumstances in which orders may be reviewable, like a violation of clearly established principle of law resulting in a miscarriage of justice. It's our position, Your Honors, that the Rodriguez Court and the later adoption of the requirements for what is a reasonably related special condition of probation are clearly established principles of law. And that being that our position is Judge Shanko did not rescind is a violation of the clearly established principle of law, allowing this court to take cert review, and we'd ask the court to take that review. And unless there's any other questions, I have nothing further.
All right. Thank you
Thank you.
both.